So the UK government proposed a change in December 2023 about stopping care workers and senior care workers from bringing dependents on their visa, and they had proposed that the change was going to be effective from the 11th of March, and today is the 11th of March, and they have released a publication to explain this as to what the criteria and what the situation scenarios are going to be, how it affects you if you're already in UK, how it affects you if you've made your application before the 11th of March, how it affects you if you're just planning to make your application after the 11th of March, or how it affects your dependent if you are on another visa and want to even switch into any of this visa. So that's the information I'm going to be sharing with you in today's video, and if this sounds like something you're interested in, do well to watch this video to the very end. And if you're not yet subscribed to this channel, subscribe to this channel, hit that subscription button so that you will get notified once we post content. So they released a document on the 11th of March titled Dependent Family Members in Work Route, okay, and that's the document I'm going to be sharing with you today. Now the document's about 38 pages, has lots of information, but I'm just going to go straight to the point to tell us the one that concerns us. All right, and yeah, so this is titled Care Workers and Senior Care Workers. Under that particular category, the first thing they say is, unless one of the exemption below apply, the applicant must not be applying as the partner or child of a skilled worker who is sponsored for a job in the occupation code 6145 care workers and home carers, or 6146 senior care workers. So they say unless one of the criteria or situation below applies, then you should not be applying as a dependent of any of these workers, either care worker or senior care worker, under the occupation code 6145 or 6146. So what are the criteria or the situations they've outlined? Let's read further to hear what it says. All right, the exemption to the rule, okay, is that if the lead applicant has continuously had permission as a skilled worker, accepting that any gap subject to paragraph 39E can be disregarded under the rules in force before 11th March 2024, sponsored in either or both this occupation code 6145 or 6146, a dependent may apply. To be eligible for this exemption, the lead applicant's original application date must have been before 11th March 2024, even if that application was granted after 11th March, and whether or not their dependent applied at the same time. Okay, so I think this particular statement here explains a whole lot of things. So it says if the main applicant has been in the UK and has been sponsored as a care worker or a senior care worker under the occupation code 6145 or 6146 before the 11th of March, and have been working in that category before the 11th of March, and they can still apply. So that's the exemption to the rule, okay? They now give some scenarios or examples to further explain what they mean, okay? The first scenario, migrant A has been sponsored as a care worker with their partner and child since 10th January 2022. Their dependent can continue to apply as such. Okay, then the second scenario is migrant B has been sponsored as a care worker since 25th November 2023, but had not applied for their partner or child. They can make an application for their dependent to join them at any time during their period of leave. Okay, I think this is very, very clear enough. All right. And the third one, migrant C has been sponsored as a nursing auxiliary since 10th July 2023, but switches to being a senior care worker with an application made on 15th March 2024. Their dependents will not be allowed to make applications in connection with their leave as a senior care worker. So for this migrant C, they were on another skilled worker route. They were on another occupation code entirely and decided to switch to the senior care worker route after the 11th of March, which is the 15th, as they have stated out here in the example. They will not be allowed to apply for their dependents on their visa, all right, because it's after the 11th of March. Okay, migrant D has been a student since 1st September 2021, then switches to being a care worker, having completed their course with an application made on the 1st April 2024. Their dependents will not be allowed to make application in connection with their leave as a care worker. So for migrant D, he switched from a student visa to a care work visa after the 11th of March. Stated in the example here, the 1st of April 2024, he will not be allowed to bring dependents on his visa. Okay, I think that is very clear enough. And then for migrant E has been sponsored as a care worker since 1st of June 2023, but switches to being a senior care worker with an application made on the 25th of March 2024. Their dependent can make an application. For migrant E, they were on a care work visa, all right, from June 2023, and then they are switching to senior care worker on the 25th of March. So because they are still within the category of care worker or senior care worker visa category, they are still able to apply with the main applicant. Okay. Then for migrant F switches from being the dependent partner of a student to being a senior care worker with an application made on the 10th of March. The partner can apply as their dependent, subject to course completion requirements. For migrant F, this is very clear enough. The main applicant was a student studying on the student visa, and then the dependent of that student got a job as a senior care worker and made their application on the 10th of March. So it says the dependent that became the main applicant or became the senior care worker can apply for their dependents when they are done with the course of their study. So it doesn't matter if the dependent who was on the student visa is going to apply with them, because he can't even apply with them because he's still on the student visa. But whenever he completes his course, even if it's a year after the partner has switched to a senior care worker route, then they can still apply. I hope that makes a lot of sense. So I think this clears the air about the whole lot of questions that people are asking. Can I still bring my family? Can I still stay in the UK if I was on a care worker route already? Or can I still switch to care work visa from another route and still bring my dependent? I think all of these scenarios and examples has made it all very clear. So what are your thoughts about these changes? How do you think it's going to affect a lot of people? I'm going to leave a link to this document in the description box of this video so that you can go and read further on it and make references to it as you wish, all right, because it was published by the Home Office. Have you found value from this video? Do also like this video so that YouTube can recommend it to other viewers. And if you've not subscribed to this channel, please subscribe to our channel so that you can get update from us. Hit the subscription button, turn on your notification bell so that you can get notified whenever we post content, all right. And you can go back and watch our other videos on how you can get a job with the NHS, on how you can make your application, on things to look out for to get a visa sponsorship job. Okay, until I come your way again, I remain Comfort Gideon. Bye.